Hello dear, thank you most sincerely for joining us on Political Affairs on Kama TV. Today we shall be looking at Adamawa Tribunal and of course the purported fixation for rulings of the Governorship Tribunal in Adamawa State. What does this speak to the preeminence of the court rulings in Nigeria as a whole? This is what we're going to be looking at on the show today, and before I get to that, I will introduce my guest who will further converse on this very talking point. My name is Chris Jacobs. Let's take a short break. We'll be back in a moment. You're welcome back, and if you just tune in, you're watching Political Affairs on Kama TV. I've been joined by Barrister Sunday Wugira, who is a lawyer based here in the city of Yola. He joins me now to further the conversation. Barrister, it's a pleasure to have you join me on Political Affairs again.
The pleasure is mine.
That's right.
Thank you.
Now, we know that the governorship election in Adamawa State had come and gone, but that's not without litigation. But with what we have seen over time, there has been this back and forth. And in recent times, the purported fixation of the date for the rulings have taken over the atmosphere in the city of Yola. What do you make of these, what do you make of these purported, fixation of date as well as unfounded rumors that has stirred up certain reactions in Adamawa State?
Well, thank you for the opportunity to be here. I think we must understand that if you look at those that are bandying the rumor that today, tomorrow, next tomorrow, the tribunal will give judgment. If you look at their backgrounds, you get to understand that majority of them are illiterates. A greater percentage of them are ignorant of the realities on ground. They are only literate. They can read and write, but they are lacking in the capacity to understand the workings of the tribunal.
Are you generalizing those who are purporting such rumors as illiterate in terms of what the judiciary is all about?
I said majority of them are illiterates, and majority of the illiterates are ignorant, assuming but not conceding that they can read and write, are ignorant of the workings of the tribunal. So they are just passing information that was given to them by someone, a ghost, in whose interest it is to bandy such information. It is a way of keeping afloat and remaining relevant. The tribunal reserves the right to give a date for judgment when the judgment is ready.
Exclusive to the tribunal.
Right. Yes, yeah, exclusively. So, whether you rush about this judgment or you don't rush, it will come. So, why are you putting pressure on yourself? Why are you making a caricature of yourself by giving a date that you know will come and pass, and at the end of the day you end up ridiculing yourself? And unfortunately, again, some people believe that some riffraffs can give a date for judgment. They should wait. The procedure is a date when it's set. Notice of judgment is given to lawyers who are involved in the matter, representing their clients.
All right. As we speak now, is there a date already fixed for the sitting?
As we speak now, as far as I am concerned, as far as I know, there is no date yet for the judgment in the governorship petition by the tribunal.
All right, but why do you think some Nigerians, preempt the outcome of the tribunal with what we have seen starting since Sunday in Yola, whereby purported rumors, is filtering around, but it's like people have already preempt what will be, the outcome of the tribunal.
People cannot preempt the outcome of the tribunal. Like I told you earlier, and I am repeating it again, the tribunal, the people that are bandying this information, they are just echoing the sound of a ghost somewhere. So it is not their own opinion. And they think that they can create a situation where they will hamstrung, intimidate, pressurize, and put the tribunal in a situation where they will find it very difficult to wriggle themselves around. But you see, they don't even know how the court system works. The court system is an independent entity, and judgments are products of what is before the court, and not the wishful thinking of someone somewhere.
All right, before we go a little bit deeper, you talked about the exclusive right to the judiciary to fix in a date of her choice. Can the judiciary or the tribunal fix a date regardless of whether it is weekend or public holiday?
Well, it can. The court judgments can be given on any day of the week, excluding Sunday.
Okay.
It can come on a Monday, it can come on a Tuesday, Wednesday, Thursday, Friday, or Saturday. But certainly not on a Sunday.
All right.
Except in very serious and grievous situations. You see, in the course of trial, circumstantially and with the agreement of all counsel, the court can sit and take evidences on a Sunday. It has happened here.
Yeah.
But you see, when it comes to judgment, judgments can only be taken on a weekday or a Saturday, but certainly not a Sunday, and then
not in any festive period.
During any festive period, except where it is absolutely necessary to do that. Like we all know that petitions are time bound. So assuming the day of evolution of a judgment, of a tribunal, of an election petition falls on a public holiday, and judgment could not be delivered before that time and cannot be delivered after that day. That is an exception.
Okay.
That
all right.
will come. So, and judgments must be delivered in an open court.
In an open court.
Yes.
So there's no secrecy to
there is
the
no secrecy.
Jurisprudence of
yes.
that judgment.
Judgments can be delivered via electronic means. We have seen here when the tribunal, the proceedings for the adoption of final written addresses took place via electronic means, that is via Zoom, the Zoom platform. But the judges were in court. You, as counsel, you can be somewhere because of certain circumstances.
That's right. Sometimes
but,
for
yes,
security reasons.
Not security reasons. Not security reasons. There is no security situation that can overpower the security agencies that cannot guarantee the sitting of a court.
All right. Let's also look at.
So let me land here.
All right.
But the judges in delivering judgment must deliver the judgment in the court hall, not outside.
In the court hall?
Yes, not anywhere.
All right. What about having a jurisdiction in terms of, if, for instance, the governorship tribunal now, must the court have a jurisdiction to deliver such judgment, whether or not it has to stay in the state or hold in the state where the election took place,
circumstances,
or it cannot hold somewhere
circumstances could warrant the court moving to another place. Like some of the election petition tribunals across Nigeria were sitting in Abuja, for reasons of security, but that also must be communicated beforehand, that for these reasons, this court sitting here for reasons of security cannot sit in Yola, but will be sitting in Abuja, and the venue must be known, the venue must be accessible, the venue must be open to parties and council involved.
And it doesn't change anything in terms of favoring a particular party.
It doesn't.
The change of venue for the sitting.
It doesn't. But you see, the change must be on reasons that is reasonable.
All right.
Well, if you could remember, the first time a letter was transmitted to council that the tribunal was no longer sitting here in Yola at the beginning, and we made representations. And looking at the circumstance, the president of the Court of Appeal directed that the tribunal should continue to sit here. So, as far as the issue of Adamawa State is concerned, we are safe. There is no security reason that will warrant moving the tribunal to another place. Even if the tribunal is to move to another place, it must be communicated to council, the venue, the court, the days of sitting must be made known to everyone. That is the
all
issue.
right. Recently, we saw where the tribunal sitting in Kano notified the election of Abagida, talking about the executive governor of Kano State. And one of the reasons why we see those rumors being peddled by those you refer to as illiterate and unfounded, knowledge about how the tribunal goes. Is there similarities between the case in Kano and that of Adamawa State that could warrant the nullification of the election of the governor of Adamawa State?
Well, I wouldn't want to go into that, but for the to clear all ghosts and doubts and any other misconception, there is no similarity between the case of Kano State and Adamawa
because
State.
there's issue of either overvoting and
you see, when you talk about overvoting, the law is clear about how to go about proving overvoting. The law is clear about what you are to bring to demonstrate the issue of overvoting.
All right, Barrister, let me allow you to catch your breath, but of course, ponder on this. When we return from this short time out, we'll still look at what constitutes the superintendents in nullifying an election. This we'll talk some more after this time out. All right, you're watching Political Affairs on Kama TV. We'll take a short break now. We'll be back in just a moment. Join us again. You're welcome back, but if you just tune in, you're watching Political Affairs on Kama TV. I've been discussing with Barrister Sunday Wigira, and of course, he has furthered the conversation the more as regard to the Adamawa Tribunal sitting and what it constitutes on. Now, before the break, I asked you this question, because we've seen what happened in Kano, but of course, there are a lot of people who are still left in the dark. What gives the judiciary, the tribunal, that superintendent to nullify an election even of a sitting governor?
Well, where there is overvoting, apparently, and there are proven non-compliance with the provisions of the Electoral Act, certainly elections would be nullified. Irrespective of who is involved. Here, for one to prove overvoting, you must bring polling unit results of particular polling units you are contending that overvoting took place. You must bring evidence of accreditation. You must bring voters register of that particular unit. And as far as the law is concerned, irrespective of whatever opinion you have, the judicial authorities that we have today in our legal jurisprudence with respect to overvoting is where the total number of votes cast in a particular polling unit exceeds the total number of registered voters in that particular polling unit. Where the total number of registered voters is in excess of the total number of vote cast in that polling unit, there is nothing like overvoting.
But if these complaints is coming from what or various units, and we've seen what happened in the just concluded presidential election tribunal, where the council or the judges, as a matter of fact, said the witnesses were not brought by the Council of the People's Democratic Party, and that again speaks more of ignorance in terms of understanding the place and the role a witness can play in such kind of situation.
Well, you can't downplay the place of a witness. That is why most political parties don't take the issue of their agents at polling units with all sense of responsibility and seriousness. You find riffraffs becoming agents in of political parties on the day of election. That is a grievous error in judgment. And it is high time political parties and even candidates in political contest took the issue of agents with all seriousness. You can't downplay the place of an agent. And when you want to prove overvoting in any particular polling unit, you can never establish that in the absence of an agent. That is the law. Because you cannot come before the court with documentary hearsay and expect the court to take that seriousness. It is with seriousness. It is not possible. So parties must know, particularly petitioners, when you prove electoral malpractices, non-compliance with the provisions of the Electoral Act, and overvoting or any electoral malfeasance, you must bring agents of the material polling units you are contending against. That is absolute. You can't go about proving malpractices without presenting witnesses
let's say
from the polling units.
With what we saw during the presidential tribunal, the councils to the PDP as well as to the Labour Party did not envisage that the need, or there was going to be a need to present witnesses, agents, even as witnesses?
Well, perhaps I wouldn't know their reasons.
But they felt as irrelevant as at that time.
I wouldn't want to go into that actually. But you see, there are situations where perhaps you may just put all these things for emphasis, but not that is your major area. Perhaps they might be looking at the areas of law where there is non-compliance, or where there is the absence of meeting the requirement of the law. You know, let me give you an example. Sometimes, if you look at the issue of 25% of the election, the vote cast in Abuja, you don't need to bring any witness there. You are talking about documents. The result itself and the outcome of the election suffices. You don't need to bring any other witness. This is a provision of the law, you know, Section 134 of the Constitution itself, you know, is very explicit about that. So you don't need to bring any witness. The court itself will take cognizance of this. That is the issue.
All right.
So sometimes you may just push some things, but actually your area of concentration and concern is in some other areas, not necessarily the issue of the electoral result itself, as in what transpired at polling units. And for want of something to say again, it is when a petitioner is contending malpractices in 100 and maybe 20,000 or let's say 10,000 polling units. How do you bring in witnesses in 180 days? 10,000 witnesses.
That is pretty difficult.
So you see, we need to also look at some of the electoral act that we have and see if we can make amendments. But you see, this amendment will never come when you know your type of representatives in the National Assembly. This is one other thing. But this is for another day.
This is for another day. Now, I know the tribunal is a court of first instance, but does the tribunal in itself have the final determinant, you know, of an election petition in terms of ruling? And for instance, if an incumbent was also ruled and whose election was nullified, like that which is seen in Kano, does that put a peg to that case, or it's still subject to review by the Supreme Court, which is the apex court in terms
for
of
the governorship election? It goes to the Court of Appeal from the tribunal, and from the Court of Appeal to the Supreme Court. And for the judgment in Kano, I am of the opinion that that judgment will not stand.
How do you mean?
The tribunal, the judges, with all due respect, they misdirected themselves and they erred in law. Because when you cancel votes that is up to 165,000, and the margin of lead between the two candidates is less than the total number of cancelled votes, you don't declare any other person a winner of the election. You declare the election inconclusive and order a rerun, because the cancelled votes is significant enough that it will have an impact on the election. You can't cancel 165,000 votes and the margin of lead between the two candidates is just a paltry 28,000 and conclude that this is the winner.
But can there be a variation in jurisprudence of justice from what we see happen in the tribunal to the apex court, the appellate, then to the Supreme Court.
Of course,
is that possibility for variation?
I believe the judgment will be set aside. That is my belief from the point of law. You understand? If you read the judgment, because I read through the judgment, and there were fundamental errors. The tribunal kept referring to Gauna as the petitioner. Gauna was never before the court. It was APC as a party that filed a petition alone. And they were referring to Gauna as the petitioner. That was an error.
All right.
You can't ascribe a non-party in any matter before the court as a beneficiary.
In the case of Adamawa State, who is the petitioner here? Is it Senator Aisha Binani or the APC or even the INEC?
The APC and Senator Aisha Binani are the petitioners. There are two petitioners in Adamawa State.
So it is okay for a candidate, who ran an election, who participated in an election, to be a petitioner?
Yes, a candidate can be a petitioner, a party can be a petitioner, both of them can be petitioners.
Then why does that of Gauna a problem?
Gauna was never a petitioner. He wasn't a party before the court.
But if he was, it would have been allowed
yes,
for him to be.
Of course.
Anyway, we're
law allows
out
him
of
to
time
be a petitioner.
completely. Thank you very much,
both of them.
Barrister Sunday Wejira. It's a pleasure to have you on the show
Thank you
today.
very much.
Well, it is said that the court is the last hope of the common man, but we're beginning to see a twist in the jurisprudence of justice in the atmosphere of the judiciary. However, there is still hope for the common man. Well, that's our show for today. Join us again same time as we come with a fresh edition of the program. Until then, stay safe. My name is Chris Jacobs.